Hello, my name is Alex Sousa, and today I will discuss patent basics. Patents are important. If you're launching a technology startup, sooner or later you will be asked about your patent strategy and how you intend to protect yourself from your competitors. Patents are also a bit intimidating. They look like a mix of a technical reference manual and a legal document. Hopefully, this presentation will help you feel more comfortable with them. And so, let's get started. There are 4 types of intellectual property: patents, copyrights, trademarks, and trade secrets. A patent is a limited duration, intangible property right that allows one to prevent others from making, using, or selling the patented invention in the United States. Copyrights protect original works of authorship, such as literature, music, artistic works, and computer software. As the holder of a copyright, you have the exclusive right to reproduce, adapt, and distribute the work. A copyright exists from the moment the work is created, so registration is voluntary. A trademark is a word, phrase, symbol, or design that distinguishes the source of the goods of one business from its competitors. For example, the Nike swoosh design identifies shoes that are made by Nike. A trade secret is a formula, process, device, or other business information that companies keep secret to give them an advantage over their competitors. Patents and trademarks are managed by the United States Patent and Trademark Office, or USPTO. Copyrights are managed by the United States Copyright Office. Trade secrets are not managed by any government agency. Okay, let's switch gears a bit and talk about the types of patents, the structure of a patent application, and the time frame and cost to get one. There are basically 3 types of patents: utility, design, and plant. I'll briefly explain each. By far, utility patents are the most typical, comprising about 90% of the patents issued by the USPTO in recent years. A utility patent is granted for the invention of a new and useful process, machine, manufacture, or composition of matter, or a new and useful improvement thereof. And they have a period of exclusivity of up to 20 years from the filing date, subject to the payment of maintenance fees. If you've never seen one, I encourage you to go to the USPTO website, or better yet, to Google Patents, and search for patents in areas that you're interested in. A plant patent is granted for a new and distinct invented or discovered asexually reproduced plant, including cultivated sports, mutants, hybrids, and newly found seedlings, other than tuber-propagated plant or a plant found in an uncultivated state. Like a utility patent, they have a period of exclusivity of up to 20 years from the filing date. However, plant patents are not subject to the payment of maintenance fees. A design patent is issued for a new, original, and ornamental design embodied in or applied to an article of manufacture. It can be very powerful, particularly when combined with copyright and trademark rights in the same design. A design patent permits its owner to exclude others from making, using, or selling the design for a period of 14 years from the date of patent grant. And unlike utility and plant patents, a design patent is not subject to the payment of maintenance fees. A provisional application provides the means to establish an early effective filing date in a later filed non-provisional patent application. And you tend to hear a lot about the benefits of filing one, that you can draft it yourself, that it's inexpensive to file, and that a patent attorney can later convert it into a non-provisional application, that is, a utility or plant application, so long as it's filed within 12 months. This statement is true, but very misleading. Here's the problem. You may end up submitting too little or too much. If you miss something in the invention disclosure when you initially filed, you're out of luck. You can't add new material after you submit the provisional application and expect to get the same filing date. But the opposite is true too. The inventor cannot prevent the public from using any information disclosed but not claimed. It may have been a better strategy to keep this information secret. Think the Coca-Cola recipe, which can then be protected indefinitely as a trade secret. My advice, if you can, is to take the time to properly prepare, or better yet, have a professional prepare the patent application. If doing a proper patent application is not an option, say you're presenting at a conference or meeting with a VC and there's no time to properly file, try to be as reasonably complete as possible. If you know you want to keep something a secret, like the specific recipe, consider not disclosing it. However, if you're not sure, my recommendation is to just include it to be on the safe side. Going forward, I want to focus on utility patents since they are by far the most common, and probably what you will do if you file a patent. Here are the parts of a utility patent: title, cross-reference to related applications, brief summary of the invention, brief description of the drawings, detailed description, claims, abstract of the disclosure, and drawings. Disclosing the invention means that the inventor must disclose the what and the how. These are called the disclosure requirements. The written description requires that all claims must find adequate support in the originally filed patent application. I'll discuss the claims in the next slide. Enablement means that the applicant must describe how to make and use the invention as to permit any person skilled in the art of the invention to do so without undue experimentation. Best mode means that the applicant must describe the best way known to the inventor on the application's filing date of carrying out the invention. The most distinguishing characteristic of a patent is probably the claim. A claim is a sentence that defines the boundary of an invention and thus the scope of patent protection. Claims are often compared to property lines because both define an area from which others may be excluded. Claim scope lies on a spectrum, from broad, excluding others from a relatively large intellectual property area, to narrow, excluding others from a relatively small intellectual property area. Here are two simple claims for a shovel. The first one is an independent claim. That is, it does not depend on any other claim. The second one is a dependent claim, since it depends and further narrows the first claim. Claim 1, a shovel comprising an elongated handle having a first end and a second end, and a shovel head, wherein the shovel head is attached to the first end of the elongated handle. Claim 2, the shovel of Claim 1, wherein the shovel head is comprised of a metal. Here's the general process for getting a patent. Initially, there's the aha moment, called conception of the invention. This is when the proverbial apple hits you on the head. Next, you have to figure out how to make or do the invention. This is called reduction to practice. Then you start preparing the patent application, normally with a patent prosecutor who sits down with you and takes notes while you explain the invention. When the application is ready to go, it gets filed at the patent office with the appropriate fees. Next comes the dance, where the patent office and the prosecutor negotiate with each other to try to get some of the claims allowed. The patent examiner sends office actions to the prosecutor, and the prosecutor responds with amendments. Eventually, hopefully, a notice of allowance is received. After the payment of a fee, of course, the patent is granted. Every few years afterward, a maintenance fee has to be sent to the patent office to keep the patent alive. An office action is a letter from a patent examiner setting forth the current status of an application. The first non-final office action usually contains reasons for any rejection or objection, or for additional requirements. For example, sometimes the claims actually describe more than one invention. Since the filing fee only covers the examination of a single invention, the applicant will be asked to choose which invention, that is, which subset of claims, on which to move forward. After receiving a response, amendment from the applicant, the examiner sends a second final office action, notifying the applicant of the status. If none of the claims are allowed, the process can be continued, with another fee of course. This is referred to as RCE, or Request for Continued Evaluation. Sometimes we use the shorthand of just continuation. Here is a sample patent application timeline. We'll set the provisional application filing as month 0. Within 12 months, a non-provisional application must be filed, or the application goes abandoned. In about 18 months, the first office action is received. Also at about 18 months, the patent application is published unless you tell the patent office otherwise. And then, one day, hopefully, the patent is issued. Here is a sample patent application timeline. We'll set the provisional application filing as month 0. Within 12 months, a non-provisional application must be filed, or the application goes abandoned. In about 18 months, the first office action is received. Also at about 18 months, the patent application is published unless you tell the patent office otherwise. And then, one day, hopefully, the patent issues. 36 months is a good, rough estimate. 36 months is a good, rough estimate. Prior art is any evidence that your invention is already known and thus legally disqualified from patent protection. There are basically two types of prior art: novelty and non-obviousness. When a patent application is submitted to the patent office, the examiner looks through the prior art to determine patentability. In order to be novel, the invention can't have already been patented or available to the public prior to the effective filing date of the invention. However, there is an exception that only exists in the United States regarding prior disclosures by the inventor. In the United States, if a public disclosure was made less than 1 year before the effective filing date, that disclosure cannot be used as prior art against the invention. However, that same disclosure would terminate any foreign patent rights. In order to be non-obvious, the examiner must not have found any teaching, suggestion, or motivation to combine prior art references to make the invention. That is, the invention is compared to the prior art, and a determination is made whether the differences in the new invention would have been obvious to a person having ordinary skill in the type of technology used in the invention. In the patent business, the person who prepares your patent application is called the patent prosecutor. Prosecution just means moving the process forward. Patent prosecutors come in two flavors: patent agents and patent attorneys. A patent agent is someone who has passed the patent bar exam but isn't a lawyer. In contrast, a patent attorney is an attorney who has passed the patent bar exam. As far as prosecuting a patent is concerned, there's no difference. But if you want to license a patent or sue somebody, you need a lawyer to do that. Here is some median cost of preparing and prosecuting a patent. That is, the money you would pay to a patent attorney or agent. A typical provisional application costs roughly about $3,500 to prepare. A typical utility patent costs roughly between about $7,000 and $9,000 to prepare. And a typical amendment costs roughly between about $2,000 and $2,800 to prepare. At the USPTO, the amount you pay is generally based on who you are. You can file as a regular entity, that is, you pay full freight, or a small entity, approximately half the cost of a regular entity, or a micro entity, approximately half the cost of a small entity. To qualify as a small entity, an applicant must be a person, small business concern, or nonprofit organization, and not have assigned, granted, conveyed, or licensed any rights in the invention. To qualify as a microentity, an applicant must qualify as a small entity, not be named on more than 4 previously filed applications, and not have a gross income more than 3 times the median household income in the previous year, or roughly $50,000. If you're getting any kind of venture funding, you should generally file as a regular entity. Although a patent portfolio can protect your company, patents themselves are not self-enforcing. You just don't call the government and say, so-and-so is infringing on my patent. Please make them stop. You have to enforce it yourself, and you have to pay for the privilege. An article published in 2013 in the IP Watchdog stated that the cost of an average patent lawsuit where $1 million to $25 million is at risk is $1.6 million through the end of discovery and $2.8 million through final disposition. If you have any questions or feedback, I'd love to hear from you. Please write me at patent@pobox.com. Thanks.